everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I will be discussing on a topic unlawful assembly. So unlawful assembly is defined under section 144 of IPC. The main ingredients of unlawful assembly are: the first ingredient that talks about that there must be an unlawful assembly of 5 persons. Second, the assembly must have a common object. Third, the common object must be to commit one of the 5 illegal objects that has been specified in the section. Further, under section 144 of CRPC that talks about power to issue order in urgent cases of nuisance or apprehended danger. This section basically gives power to district magistrate or subdivisional magistrate or any other executive magistrate specially empowered by the state government in this behalf to issue order in the case where he has sufficient ground to take the action and for the immediate preventive or speedy remedy is desirable against the apprehended danger. The main object of section 144 is to pass an immediate order in advance to prevent any apprehended danger or immediately give a remedy in case of an emergency. Further, to prevent peace in the society is the prime purpose of the state government. Hence, the government specially empowers executive magistrate under section 144 to take an immediate action in case of an emergency. Further, to provide an immediate remedy in the following 3 situations mentioned under clause 1 of section 144 of CRPC. So, the first situation is to prevent any obstruction, annoyance or injury to any person lawfully employed. Second, a danger to human life, health or safety. Third, to disturbance of public or riot or any affray. The prohibition of the right to assembly is not adequate. Now, there was a case, Dr. Anindya Gopal Mitra versus State. In this case, it was being held that the amount of power that is being vested under magistrate under section 144 is to suspend the exercise of the right on a particular occasion and not to prohibit it absolutely. In this case, the police commissioner refused to give permission to the political party to hold a public meeting by prohibiting it under section 144 of CRPC. Although Honorable High Court of Calcutta quashed the order that was being passed by the police commissioner and said that the holdings of meeting could not be totally prohibited but necessary restriction may be imposed and preventive measures may be taken. Further, section 144 that talks about duration of applicability, where it was stated that no order under this section shall remain in force for more than 2 months from the date of issuance, provided that the state government, if of the opinion that it is necessary to do in case of an emergency or to prevent danger, human life, health or safety, or to prevent a riot, then the state government may order the magistrate to make an order to extend the period of applicability of section 144 not more than 6 months. As this section confers full power to magistrate to take certain action to apprehend danger in case of emergency, magistrate should apply his mind to see whether the matter is of such nature which requires an order under this section, as otherwise a matter to disperse unlawful assembly by creating public nuisance can be dealt under section 133 of CRPC. Further, according to section 142 of IPC, which talks about whoever being aware of the fact that makes an assembly unlawful intentionally joins that assembly or continues in it, it is said to be the member of the unlawful assembly. Further, punishment for unlawful assembly is being provided under section 143 of IPC that whoever is a member of unlawful assembly shall be punished with imprisonment that may extend up to 6 months or with fine or both. Then further section 144 that talks the punishment given here is imprisonment for a term of 2 years, fine or both. Further section 145 of IPC, the imprisonment which has been given under this section is of 2 years, fine or both. Further, under section 149 of IPC that talks about where an assembly commits an offence, then every member of that assembly who knew such offence is likely to be committed will be guilty of the offence and be punished for the term same as for the offence. Thank you.